questions are also on the chat box, sir. The first question is from Ms. Rishvi. It says, since we have no concrete international regulatory body in regards with spatial industrial activities, it can so happen that space can get heavily privatized and add to the existing space debris and excessive resource exploitation. How can that be helped and regulated at the level of implementation?
The question is concerned, I think probably the question is in terms of how to regulate the space industry as it is adding on to the already existing debris problem. Isn't that? That's the primary question, isn't it? Yes. Okay, I think so. Yeah, I think that's the question. All right. Yeah, so if we look at the international level, there are actually some developments which are going on with respect to space debris mitigation. Guidelines have been brought in. We have the UN-OSA guidelines, NASA guidelines, different actually agencies. European Space Agency is also developing the guidelines. IADC has actually developed the guideline with respect to the space debris mitigation. However, yes, that there is no separate international body which has been established as of now for the purpose of checking the debris and then regulating the space debris creation. It doesn't mean that the states should not take action at their municipal level to prevent this. As I think both myself and Professor Keret has already pointed out, under Article 6 of the Outer Space Treaty, every state has got a responsibility to ensure that activities of even private players are carried on in a sustainable manner. It should not be actually carried on in such a way that it would cause any detriment to the interest or benefit of the mankind, since Article 1 of the Outer Space Treaty already imposes an obligation to carry it out for the benefit and interest of all countries. So therefore, as of now, in the absence of an international body to regulate the debris creation, to my personal understanding, we should go by creating such kind of a body at the national level during the process of licensing itself. When a state is licensing, it should have the conditions, particular conditions with respect to debris mitigation as well, end-of-life maneuvering of the satellite. So they should have a condition in the license itself so that the private players can be regulated. And if I have to connect further into the international obligations, something which most of us forget is Article 3 of the Outer Space Treaty. If we look into Article 3 of the Outer Space Treaty, it speaks about application of international law, including Charter of United Nations for every activities in outer space. And I have tried to argue that whatever developments which have taken place in international environmental law at present, all sustainable development concepts, of course, one of my papers which has been published in the Annals of Air and Space Law, the McGill University is actually the journal, therein I have argued that we have to actually transport the principles of international environmental law to the outer space through the channel of Article 3 of the Outer Space Treaty for the purpose of better protection of the outer space. So probably that would give the answer how to regulate actually the, especially in case of the private commercial space activities.
Thank you, sir, for your response to the first question. Now we move ahead to the next question, which is from Professor Chanchna. It says, when we know the situation regarding space activities are increasing, what, according to you, can be a workable solution? Isn't there a possibility of the developed states to dominate the situation to their benefit? This question is addressed to Sandeepa sir.
Oh, okay. So a question directed to me. Thank you for the question. Of course, the developed states would definitely dominate, not because of the law, but because of actually the technical developments. And this is something which we cannot negotiate at all, simply because actually in, say, the western part of the world, there is more developments in terms of space technology. We can't say that they should not carry on the activities and we should only be carrying it on. But what we need to ensure is that if the private players are carrying on activities in the western part of the world, they are not going to carry it on in such a way that it causes detriment to the rest of the mankind. It should be ensured that all activities are going to benefit everyone. So maybe this should be more in terms of actually the regulation at the national level. Article 6 of the Outer Space Treaty, as both of us have already discussed just before, states before granting a license has to consider whether the private players' commercial activities are going to benefit the mankind either directly or at least indirectly. Right? So at least indirectly, is it benefiting the mankind? That has to be looked into, and accordingly the licenses need to be provided. So dominance of actually the developed countries, we cannot actually negotiate with the law. That is not an answer. If at all we have to negotiate, we have to develop our technology. We have to ensure that actually our technology is also equally good that of the United States, Russia, or maybe European the states.
Thank you so much, sir. We now move ahead to the next question, which is from Prithvi. Why have the international bodies kept mum on selling the land on moon? Isn't this $1 trillion scam?
With respect to the regulation of exploitation of space resources, you can find that under Article 11 of the Moon Agreement. Outer Space Treaty has got the general norms. It basically speaks about declaring the outer space and celestial bodies as province of all mankind, freedom of exploration and use, but at the same point of time, no national appropriation. That has been actually mentioned in the Outer Space Treaty also. But more specific aspects with respect to the celestial bodies or their resources are concerned, you can find under Article 11 of the Moon Agreement, which advocates for the common heritage of mankind principle. And Article 11, paragraph 5 says that there is also a requirement of establishing an international regime as such exploitation is about to become feasible. That's what Article 11.5 says. This is primarily because at the time when the Moon Agreement was actually basically being drafted, there was no consensus on a separate norm. There was no consensus as to how the international norm need to be developed, especially because at that time, going to the moon or celestial bodies and then carrying on extensive activities, that did not happen during that time. So drafters, they basically believe that unless and until we get to know about all information about the celestial bodies and their resources, we might not be able to develop a comprehensive regime, and they kept it for the future. 11 paragraph 5 says that as such exploitation becomes feasible, we will develop a particular norm. But unfortunately, Moon Agreement has been signed and ratified only by 18 states. And majority of them are not even spacefaring nations. They're not even spacefaring nations, right? Maybe only Australia and a couple of European countries. Apart from that, nobody else is having even space activities. And even Australia and most of the European countries are also having activities only in outer space, not on celestial bodies. Not on celestial bodies. Moon Agreement is on celestial bodies. So that is why applicability of the Moon Agreement and the international regime itself has become a kind of actually question. But that doesn't mean that the private players can claim property rights, they can sell that, because already we have Article 2 of the Outer Space Treaty, which is prohibiting national appropriation, including individual appropriation. Both of them are prohibited in Article 2. Plus, Article 1, when it says that outer space has to be used for the benefit and interest of all, how can actually it could be used if an individual person is selling the property on the moon and other celestial bodies? Is it for benefit and interest of everyone? Absolutely not. So therefore, international regime is already there. Only thing is proper implementation in the domestic level is required by the respective states.
The Moon Agreement was prepared under the UN Corpus, was accepted by consensus within the UN Corpus, and then decided by, voted by, well, accepted by consensus within the United Nations General Assembly. And the text of this was very much pushed by the US delegation at the time. And we have to keep that in mind. The Moon Agreement is a good text, but it has been pushed away for political reason after the fall of the end of the Cold War, because then we had no equilibrium between states. And the Moon Agreement by itself is quite good, but for political and ideological reasons, it is left aside. But I think it is rather a good agreement, and it should maybe the basis of a legal framework for activities on the moon and other celestial bodies. Thank you.
Thank you, sir, for your enlightening response. Thank you so much. We move ahead to the next question. It is from Mr. Kannan. It says, may I know the current and future scope of India in space tourism?
Okay, so let me take this question since it is specific to India. Yeah, I mean, of course, there is a huge scope for India being a kind of a hub with respect to space tourism, especially because of the cheap launch from India. If you look into the status across the globe, if you launch from India, we have actually an advantage in terms of it being very economically being viable. But the only thing is that the private players are having a problem with respect to the law. As of now, we haven't actually developed the national space legislation, even though we are in that process. The draft has been prepared in 2017, but there are a lot of loopholes actually. Even in fact, I have commented on that. One of my papers is also published this month itself in the New Space Journal. Of course, 2017 draft has got its own limitations. Maybe the private players are waiting for clarity in terms of law as far as their liability is concerned. How far they are liable, to what extent coverage need to be taken by them for carrying on the space tourism activities. That is what is basically they're waiting for. And once actually that happens, we'll be having a lot of actually space tourism activities from India itself.
All right, now we move to the next question. This is from Professor Chanchana. How far the public trust doctrine can come into play for the states to take responsibility regarding space activities? The question is open for both the speakers.
I should say that public trust doctrine is already there in the Outer Space Treaty, and Province of All Mankind and National Law of Corporation are the reflection of actually the public trust doctrine.
All right, we move to the next question. With no one having sovereignty, these private operators are annexing them. Isn't it, sir? It may become colonized. I would repeat the question.
I got the question. Since nobody is having the sovereignty, so can the private players claim the property and colonize it? Let me tell you that since no one is having sovereignty doesn't mean that the private players can claim property rights. For that, you need to understand allocation of the property in both common law system as well as civil law system. If you look into the allocation of property in common law system, all land property is allocated by the state charity. Unless the state owns actually the land, the private players cannot own it. So when the state itself is prohibited under Article 2 of the Outer Space Treaty from claiming any sovereignty or rights over the land, even individual from common law country cannot claim any property right. There is no possibility of state transferring that right. Similarly, if you look into the civil law country, of course, in civil law country, there might not be a requirement of state owning the property for granting. A private individual can go and occupy a particular land which is terra nullis, which does not belong to anyone. They may develop that, and the state can recognize the property right for the labor, whatever has been put in by the private player in the development. That's how actually the civil law countries grant the property rights to an individual. However, outer space and celestial bodies are not terra nullis. They're not something which do not belong to anyone. They belong to everyone. They're the province of all mankind, right? They belong to everyone. So precisely because of that reason, even an individual from the civil law country cannot go there, cannot develop that property and say that this belongs to me now because I have occupied this property. So therefore, no question of private appropriation, no private colony. So there is a complete ban on both state appropriation as well as private appropriation.
Yes.
So,
I may add some words. I share this view, and it's quite important to keep in mind that it is outer space is not res nullius, it is res communis, which is quite different. And res nullius may be appropriated indeed, but it is not the case of outer space because of Article 2 of the Outer Space Treaty. Of course, it's true that we need this Article 2 in order to avoid having this occupation by anybody, but still by states, not by private activities, because only states can have sovereignty over a territory, not private. So it is quite important to keep that in mind. Res communis, not res nullius. Thank you.
I would like to thank both our resource persons for answering the questions.